Na wengi wanapoulizwa kwamba makosa aliyofanya ni yapi, hawataweza kujibu kwa sababu makosa ambayo wamefanya wote wamefanya kule bungeni.
Na nafikiri tujikumbushe kwamba hata kuteuliwa kwake kuwa mgombea mwenza kulikuwa na matatizo ambayo yalidumu siku 3.
Naam. Na unajua wakati nilipokuwa naondoka mamlakani kama rais wa muungano wa mawakili, nilijibiza mmoja ambaye alikuwa ananisumbua sana katika huduma yangu. Nikamwambia, hata wewe unaona uko na sauti lakini haufanani kama rais. Unajua rais huwa wanafanana kama rais. Anapoingia unajua jamani rais. Lakini sasa wewe kazi yako tu ni kupiga gumzo, simulizi ambazo zinazingatia ukabaila. Mwalimu Julius Kambarage Nyerere ikiwa angefufuka asikize mambo kama angesema Afrika Mashariki imeporomoka. Na Kenya ambayo ilikuwa katika mstari wa mbele kutoa mwelekezo imetuangusha.
Wakili, siku ya Jumapili baada ya sherehe za Mashujaa Day kuandalia Kwale, naibu rais aliazimia kufanya mkutano na wanahabari akitoka hospitalini. Kuna masuala mazito ambayo alizua pale ya Kwale. Naibu rais aliazimia kufanya mkutano na wanahabari akitoka hospitalini. Kuna masuala mazito ambayo alizua pale, na cha kushangaza kwa wengine pengine ni kwamba alizungumza maneno ambayo hakuwa ameandamana na mawakili wake. Umezungumzia swala zuri kwamba baada ya hapa huenda akapata changamoto nyingine nyingi za aidha kufunguliwa mashtaka, uchunguzi kuhusiana na masuala ya kwa kimombo watu wanasema economic crimes na kadhalika. Unahisi kwamba pia baadhi ya maneno aliyotamka siku ya Jumapili pia huenda baadaye yakamponza? Matamshi ya kwamba niliandamwa, kuna mtu alitaka kuniwekea sumu na kadhalika. Ikumbuke kwamba leo alilazimika ama alitakiwa kufika katika makao makuu ya DCI kuelezea sababu zake, kueleza hilo. Unahisi kwamba baadhi ya mambo ambayo huenda baadaye pengine hakufikiria wakati huo lakini akajutia baadaye ikiwa yatamwandama?
Sidhani kama kutoka wako na majuto. Mimi ni kiongozi. Majaribio ya kunipea sumu ya mawahi fanywa. Majaribio ya kunidhulumu ya mawahi fanywa. Wakenya wanajua jambo kama yeyote ambaye anachukua jukumu la kuwa kiongozi lazima atarajie kukabiliana na mambo kama haya. Na tujiulize, ikiwa kulikuwa na jaribio hapo awali, mbona hatukuelezwa? Mbona mambo haya yanasimuliwa baada ya kutimuliwa mamlakani? Na wacha nikwambie ukweli kaka, ikiwa rais anataka kuua, jambo hilo hata wewe utasimulia, utauawa mara moja. Na si Kenya peke yake, hata mataifa ambayo yamekuwa katika kidemokrasia. So halitakuwa jambo bora kwa Kenya kusikiza simulizi kama hili. Tuzingatie jambo ambalo limetuleta hapa wakati huu ni ukosefu wa maadili katika uongozi walikuwa na naibu wa rais Rigathi Gachagua. Hayo ndiyo mambo ambayo yapaswa tutizame kwa undani. Na lalamishi ambalo limepelekwa mahakamani wakati huu ni kwamba hakukuwa na mwelekeo bora kwa upande wa bunge wakati ilipokuwa inasikiza kesi hii. Hilo ndilo jambo ambalo lapaswa sisi tusikize. Ikiwa watamfuata katika siku za usoni kuhusu matamshi yake, hofu yake, na sisemi kwamba hofu yake haina msingi. Kenya ni nchi ambayo inahudumu kwa msingi wa kisheria na katiba. Itakuwa jambo baya sana ikiwa yeyote atataka kumhujumu rais, atataka kumhujumu naibu wa rais ama Mkenya wote. Na mimi kama mtetezi wa haki za binadamu atataka kumhujumu rais, atataka kumhujumu naibu wa rais ama Mkenya wote. Na mimi kama mtetezi wa haki za binadamu sitakubaliana na hujuma yoyote ambayo lengo lake ni kutoa maisha ya mwanadamu ama kumdhulumu. Lakini kwa sasa sidhani kama jambo hilo limetendeka.
Naam, asante. Wakili, wahenga wanasema kwamba siku ya nyani kufa matawi yote huteleza, ama miti huteleza. Kwenye tajriba kuu, wakili mkuu Paul Mwite, Elisha Ongoya, Mwendwa na kadhalika, unahisi tawi gani sasa wataweza kushikilia katika kesi hii angalau iwape afueni katika kutazamia kupata pengine uamuzi ambao utawaridhisha na kumridhisha mteja wao?
Hawana tawi la kushikilia, lakini kile kitu ambacho naibu wa rais, aliyekuwa naibu wa rais anapaswa kile kitu ambacho naibu wa rais, aliyekuwa naibu wa rais anapaswa kujua ni kwamba kwa yale yote ambayo yametendeka, uamuzi ulishafanyika. Na anafaa ajue kwamba Wakenya wanaenda mbele, hawatarudi nyuma. Kile kitu ambacho anastahili kufanya ni kupigania kuwa yale madai ambayo alichukuliwa nayo hatia, koti iweze kumsaidia kuondoa hiyo dosari. Hilo ndio kitu ambalo peke yake koti inaweza kumsaidia. Lakini kwa maneno ya kung'atuliwa ofisini, alishang'atuliwa, ilishaisha, ni mambo tu ya kureview kwamba ilitendeka kwa haki. So jambo la maana ni kuondoa hiyo dosari, kwa sababu vile mkubwa wangu wakili Havi amesema, koti haiwezi reverse ile decision ya impeachment, na koti haiwezi mrudisha mamlakani. Ni nini ambalo koti inaweza msaidia, na ni nini ambalo linaweza saidia maisha yake na watoto wake na kizazi chake? Ni kwamba kusema kwamba haya madai hayana ile ushahidi wa kutosha kuwa madai kwamba aliweza kufuja pesa za ndugu zake ama mali ya marehemu ndugu yake, ama kufanya kitendo kile ambacho yale ambayo yote amewekewa. Hilo ndilo jambo la maana, na hata ukaniuliza mimi, jambo la maana lake la kufanya ni hilo. Ya kisiasa, mahali ako katika ile ambayo tunaita political oblivion, ni kwa akili yake na mipangilio yake, na anashuku sana kama ako na hiyo mipangilio ndiye anaweza kujitoa. Lakini kulingana na sasa vile siasa amecheza, sidhani kama ako na hiyo tajriba ya kucheza siasa akafika ile ligi ambayo watu wengine wamefika, kwa sababu kwa muda mchache ambayo alipewa nafasi. Unajua, ukiangalia historia yake, alikuwa dio, akawa mbunge kwa first term, akawa naibu wa rais. Na kwa hiyo haraka ambayo umeiona kwa mtu kuwa first term MP na kuwa naibu wa rais, kwa hiyo muda wa haraka tena ameng'atuliwa. So inamaanisha kitu ambacho kinafaa kikuwe kinamhusisha sana ni kutoa hayo madai, labda ndio kitu cha maana sana.
Wakili Havi, kwa mtazamo wa wengi, nafikiri naibu rais aliondolewa Rigathi Gachagua, pengine anaonekana mtu mwenye ujasiri, mtu mwenye ubabe, kutokana na matamshi yake na mienendo yake. Unahisi kitu gani ambacho kilimfanya sitake kujiuzulu, iwapo pengine kama alivyosema Kalede hapo awali kwamba pengine hakuwa amejiandaa kikamilifu kwa hatua ambazo zingemkabili mpaka tufikie kiwango hichi? Ingekuwa bora pengine kujiuzulu au la?
Hata ingelikuwa ni mimi singejiuzulu, kwa sababu nilisema unapochukua jukumu la kuwa kiongozi, matarajio yako ni kwamba kuna watu watakuja kulumbana na wewe. Uongozi si jambo la urahisi, na wakati mwingine ni bora upigane. Ikiwa utafanikiwa sawa, ikiwa utaangamizwa sawa. Unamkumbuka rafiki yangu Saddam Hussein alisema kwamba yeye atapigana nao, litapofika wakati yeye kutiwa kitanzi hata kuwa na uoga. Basi hilo ndilo jukumu la kiongozi. So ndugu yangu Rigathi Gachagua, pigana mahakamani, pigana. Ukifanikiwa basi hongera, kama hutafanikiwa ni sawa. Hivyo ndivyo maisha ya kiongozi huwa.
Basi kwa nini inatokea mara nyingine wakati unapoandamwa na matatizo kama haya kwamba baadaye unajikuta upweke? Ni kwa sababu kuna shinikizo kutoka afisi za juu zaidi kwamba wengine hawawezi kuunga mkono? Manake akianzia katika pilika zake za unaibu rais, alikuwa na wafuasi wengi katika mikutano ambao pia anashutumiwa kuzungumzia, kwa mfano swala la ambalo limetajwa kama la ukabila, ama washikadau fulani katika taifa hili watapewa vyeo, vitakavyobakia ndio vipewe vingine. Matamshi yale alikuwa akitamka mbele ya hadhara, nyingine hata rais alikuwako na wabunge walimshabikia. Kuna wakati unaposikia watu wanacheka, wanapiga makofi, lakini kwa sasa hivi anajikuta katika hali ya upweke. Kwa nini mara nyingi huwa inatokea namna hiyo?
Si kweli. Mimi hutembea sana. Juzi nilikuwa katika sehemu ya Nyanza na mkoa wa Magharibi. Kwa raia wa kawaida kuna wengi ambao wanamuunga mkono. Na wanamuunga mkono kwa nini? Kwa sababu kwa maoni yao wanafikiria kwamba anadhulumiwa. Na yeyote ambaye anadhulumiwa maishani, hata wewe saa hii ukipelekwa kizimbani, ikiwa uko na dosari kubwa sana, wengi watakuonea huruma. Na jambo la pili ni kwamba raia wa kawaida wengi wanamuonea huruma kwa sababu wanajua kunao wengi katika serikali hii ambao kuna dosari kama Rigathi Gachagua. Si kwa sababu wanampenda, ni wachache ambao wanampenda. Ingekuwa mapendeleo ya wengi wa Kenya kwamba hata wabunge wote watimuliwe. Na waweza kuona kwamba wale ambao walikuwa na ushawishi kama Rigathi Gachagua wamepungua. Lakini jambo fulani ambalo hatuwezi kutupilia mbali, kura iliyopigwa katika bunge la juu la seneti ilikuwa na wengi wa maseneta kutoka eneo la Mlima Kenya ambao walimuunga mkono. Walewa, sijui jambo fulani huenda sisi hatukuliona, lakini wao wako na haki ya kumuunga mkono. Na wale ambao pia walitoa uamuzi kwamba atimuliwe wako na haki ya kufanya jambo hilo, kwa sababu bunge limepewa hiyo nafasi ya kufanya jambo hili. Na ikiwa bunge litafanya jambo hili, ijapokuwa sisi hatutakubaliana nao, ijapokuwa wananchi wa kawaida hawatakubaliana nao, huo ni uamuzi ambao bunge umepewa mamlaka katiba kutimiza. Na ikiwa wananchi wa Kenya wanaona kwamba kuna makosa katika namna ambayo bunge lilifanya jambo hili, basi wako na uwezo wa kuwaita na kuwatimua hao wabunge kupitia huo mwelekeo uliowekwa na katiba, kwamba waweza kumwita na kumuondoa mamlakani mjumbe wako, iwe ni MCA, iwe ni mwakilishi wa constituency, iwe ni mwakilishi wa wanawake, iwe ni seneta. Wako na jukumu kama hilo. Na mimi kama mtetezi wa Kenya, kama wakili ambaye anazingatia katiba, na nimesema jambo hili kwa muda mrefu, bunge la Kenya limekaidi katiba. Na ikiwa bunge limekaidi katiba, basi lililopo ni wale ambao wanawachagua hao wabunge wafanye kazi kulingana na sehemu yao. Waweza kuwaita wakati huu, ama itakapofika wakati wa uchaguzi wafanye uamuzi ambao unaambatana na maoni yao.
No. Wakili Kalende, kwa mtazamo wako, kuna masuala ambayo pengine hatujui yatazuka katika kesi hii, pengine kwa mtazamo wako tudakie kwa kifupi tu, ni masuala gani ambayo pengine hatujatazamia yatatokea katika kesi hii ambayo pengine huenda yakajitokeza?
Kile kitu ambacho kitatokezea kwa haya mambo yote, ya kwanza, hata wakili Havi ameelezea kwa mtandao wake wa kijamii, amesema kwamba ndio wamemngatua naibu wa rais, lakini ile kiwango ambacho kimetumika kiko chini, na ni wakati ambapo Wakenya watukue hii nafasi kungatua ule kiongozi ambaye wanaona hafanyi majukumu yake. Na kitu ambacho Wakenya wameonesha kwa huu mwaka mmoja, wameonesha kwamba wako wanaweka wa viongozi kwenye ratili na wanawapima kila siku, mchana na usiku, na ile siku ambayo itapatikana ama nafasi itapatikana ya kutimua kiongozi yoyote, Wakenya hawana budi bali watamtimua mtu yoyote.
Unavyosema ni kweli kwamba Wakenya sasa hivi wako macho. Wameiweka serikali hii nafikiri katika hali ya kuipima kwa nguvu na kuiangazia kwa mtazamo mkubwa, hata kushinda serikali nyingine. Ina maana kwamba hata imefikia kiwango ambapo serikali hii imepoteza umaarufu kwa wakati mdogo sana. Sasa mchakato kama huu, ama matatizo malumbano kati yake naibu rais na Rais William Ruto, pia yanaonyesha kwa kiwango fulani kwamba pia rais mwenyewe licha ya kudaiwa kuongoza mchakato huu, ni kwamba pia vile anaonekana kupoteza umaarufu. Sasa hapa ndio mwisho, sasa anaanza upya ama namna gani kama rais?
Kama rais alijua vyema kwamba wakati wataanza wataanza haya mazungumzo ya kumuondoa naibu wa rais, alikuwa anajua vizuri sana mpaka jina lake litatajwa. Na kwa hii vita, unajua wakati unaenda vita, hata kama umemshinda mtu haimaanishi utatoka vile vizuri, utatoka na majeruhi. Kuna yale majeruhi ambayo rais anaenda kupata kutokana na haya mazungumzo. Tuliona kule seneti vineo fulani ambalo rais anapaswa kuwa na umaarufu, walimpigia Gachagua. Ukienda vile vile kule bungeni vile walipiga, inaonyesha kwamba ana upungufu area fulani. Lakini jambo ambalo rais amefanya kwa haraka sana na ambalo Wakenya wanafaa wajue ni kwamba tuko sahi kwa ile serikali ambayo tunaita broad based government. Tayari realignments mpya tukiangalia 2027 zimeanza kufanyika, na kwa huu mpangilio rais tayari amejua kwamba kuna majeruhi atapata mahali fulani na lazima ajipange ili kuziba hilo shimo. So hayo ndio mazungumzo ambayo kwa siasa yataendelea kuwa, hiyo realignment mpya ambayo itaendelea kuwa. Ndio.
Wakili Nelson Havi, nafikiri kwa kutazama jinsi ambavyo Rigathi Gachagua ameandamwa na hata kutimuliwa mamlakani, linazua swala moja ambalo ni la kikatiba, kuangazia majukumu ya naibu rais ni yapi. Kwa bahati mbaya inatokea kwamba katika katiba yetu hana majukumu zaidi ila tu kuwa msaidizi. Unahisi kwamba angekuwa na majukumu mengine? Kwa mfano, kuna watu wametolea mfano wa Musalia Mudavadi ambaye ni mkuu wa mawaziri, akiwa anaonekana kuwa hata na majukumu zaidi kumshinda naibu rais. Sasa sijui ni tatizo la kikatiba, tumejikuta katika tatizo hilo ama namna gani?
Si katiba iliyo na ubaya. Rais Dr. William Samoei Ruto alihudumu kwa miaka 10 kama naibu. Mbona wakati ule hatukuwa na tatizo kama hili? Kwa sababu alikuwa mtulivu. Alijua kwamba jukumu lake ni msaidizi. Na msaidizi huenda hivi chini ya maji. Thibitisho la wale ambao wamefanikiwa kama wasaidizi na wakawa wakuu: Daniel Arap Moi, mtulivu; Mwai Kibaki, mtulivu; Dr. William Samoei Ruto, mtulivu. Na si kwamba huyu Dr. William Samoei Ruto ni mwoga. Huyu ni bepari. Lakini alikuwa na ufahamu kuhusu jukumu lake kama naibu wa rais. Na hata kuna wakati alikuja hadharani akasema, mimi msinione hivi nimenyamaza, najua kazi yangu, sababu nikianza kupiga mayowe hapa mkubwa wangu atatitimua. Lakini huyu jamaa kaka yetu mzee, kila siku porojo, kelele. Jambo ambalo liliwakera wengi wa Kenya na wabunge ni hili: kila kuchao alikuwa anaamka, Mrima. Wewe ulikuwa naibu wa rais wa Mrima ama wewe naibu wa rais wa taifa la Kenya? Waelewa? Na yeyote ambaye atataka kuhudumu kama naibu wa rais, mimi singelipenda kuhudumu kama naibu wa rais, sababu mimi nimekuwa rais. Sitawahi taka kuhudumu kama naibu wa rais. Kama nataka kuhudumu lazima niwe rais. Lakini ikiwa wewe utapendelea kuhudumu kama naibu wa rais na ikiwa wewe utakuwa naibu wa rais wangu, lazima ucheze chini. Ufuatilie mwelekeo ambao umeletwa na mkubwa.
Basi niulize, kwa mtazamo wako, ni kipi ambacho pengine angefanya ajirudi nyuma? Manake nafikiri kwa mwaka mzima huu malumbano yalikuwa yameshaanza. Kwa mtazamo wetu pengine
wacha kukatiza hata kabla hujaenda mbele. Hakuna chochote ambacho angelifanya. Ni maumbile yake. Unajua kuna watu ambao dosari yao ni maumbile. Kwa mfano kama mimi, watu wanasema yule jamaa anapenda kuongea, ako na kiburi. Makosa si yako, ni maumbile yangu.
Naam.
Lakini so, maumbile yake ambayo yamemleta chini. Bila
shaka, lakini nafikiri kuna wakati ambapo unaangalia maumbile yako na unaangalia mtazamo wa Kenya kwa ujumla na kiongozi wako, unajirudi nyuma. Nikupe mfano kwamba nafikiri kwa baadhi yetu ambao tumemtazama kwa muda mrefu na matamshi yake, haswa Jumapili. Nafikiri kuna kisa ambacho kilitokea wakati rais akiwa katika siwezi kukumbuka ni kanisa gani, lakini ilikuwa ni matukio kanisani ambapo naibu rais alitarajiwa kuwa pale, na nafikiri ilikuwa sehemu moja kule Milimani. Naibu rais akatangaza kwamba amekwenda kwengine na kwamba hakutarajiwa kufika kule kwa sababu shughuli zinaendelea na yuko sawa. Unahisi hapo ndipo nafikiri pengine rais alifika kikomo, akaona kwamba nafikiri hapa sasa ndio imefika mwisho. Maana kulikuwa na kiti chake pale, na haitokei namna hiyo kwamba ikiwapo naibu rais haji katika kikao cha rais, huwa matarajio yamepangwa tayari kwamba hastahili kuwa pale. Sasa sijui ni wajua sisi wanahabari
wacha nikukosoe. Waliomtimua mamlakani Rigathi Gachagua wanajulikana. Ni bunge, si Rais Dr. William Samuel Ruto. So yani kwamba jambo ambalo unaguzia liko na uhusiano wote kuhusu namna ambayo
wajua. Lakini kwa nini nasema hivyo? Kwa sababu kuna mambo amefanya aonekane ni kama anajaribu kumwaibisha rais. Kwa mfano, ufike mahali useme sikupata ndege kwa wakati, kwa hivyo nikachelewa, nikafika mahali nikapata kuna traffic kama kitu. Wajua kuna mambo huwezi kumwambia bosi wako saa nyingine. Kweli ama si? Unajua
mambo kama haya ni madogo madogo, na mimi na ndugu yangu hapa ni watu wakubwa. Hata tungeweza kuzungumzia maneno madogo madogo kama sababu mwenyewe amesema yeye hana upungufu wa pesa, hana upungufu wa uwezo. Na mimi kwa mfano, ukichukua gari ambalo nilipewa na serikali, sitaanza kupiga mayowe kwamba umechukua gari. Niko na gari yangu, nimekuwa na magari kwa miaka karibu 25. Nitachukua tu gari na niende. Iko ulialikwa kwenda kanisani, habiri gari lako na uende. Na kama unataka kwenda na ndege, chukua ndege na uende. Na tuliona alivyohudumu Dr. William Samuel Ruto. Sisi tuliabiri na yeye mara kadhaa. Hata huyo jamaa alikuwa na habiri. Hiyo ndege ilikuwa ya serikali ama ilikuwa ndege yake?
Ilikuwa laki.
Ilikuwa ndege yake. Basi jambo gani ambalo tunajadili?
Anakodisha kibinafsi.
Alikuwa na ndege yake. Kodisha ndege yako. Wewe ni naibu wa rais, uko na uwezo. Hata kabla hujakuwa naibu wa rais ulikuwa na uwezo. Usije hapa kila siku malilio ambayo hayana msingi, ambayo yanaleta afisi yako chini. Na ni mambo kama hayo ambayo sisi tunayangalia, tunasema kwamba hapana, huyu afanani kama naibu wa rais, huyu afanani kama rais. Je, angelikuwa rais alafu mzunguko wake uwe tu mlimo wa Kenya, tungedhulumiwa sana kama wa Kenya. Watizama.
No. Actually kuongezea ni kwamba kile kitu cha maana sana ambacho wakili Havi anasema ni kuna ule mtu ambaye maumbile yake inampea nafasi nzuri sana kuhudumu kama naibu wa rais, na kuna wale ambao wako na maumbile ambayo kuhudumu kama naibu wa rais hata siku moja hawawezi. Na jambo kubwa ni kwamba Rigathi Gachagua angepaswa kuelewa kazi yake kama naibu wa rais inamaanisha nini, na kwa mtazamo wangu hakuelewa kazi yake kama naibu wa rais inamaanisha nini. Na kama uko na ambition, kwa sababu tukiangalia rais wa sasa William Samuel Ruto, kwa wale ambao wanamjua vizuri na vile tumeangalia historia yake, wakati alikuwa naibu wa rais alielewa kazi yake ya kuwa naibu wa rais, na alielewa ambition yake ya kuwa rais inaanzia wapi na ataanzia wapi na atamaliza aje, na ataanzia wapi na atamaliza aje. Lakini kwa huyu Rigathi Gachagua hakuelewa kazi yake kama naibu wa rais, na hakuelewa hii ambition yake ya kukuwa rais wa Kenya itaanzia wapi na itaelekea wapi. Kwa sababu kama uko na, mimi kwa mtazamo wangu, kama niko na ile fikra ya kuwa rais, siwezi anza leo kuanza kutamka matamshi kwamba Kenya iko na hisa, na kama hauna hisa kwa hii serikali hautakuwepo. Kwa sababu wakati itafika kwa kura, wale watu wa pande ile nyingine wataniuliza, kwa hii serikali yako tuko na hisa kweli? So ni jambo ambalo wengi kwa tunasema, mimi kwangu ni ile maumbile yake hayakumpea nafasi kuelewa kazi yake na kuweza kutimiza ndoto yake.
Asante sana wakili Nelson Havi, wakili Joe Kalende. Kwa heshima ya mahakama, nafikiri kikao kiko karibu kuanza, na nafikiri tutaelekea kule. Natoa shukrani za dhati kwa kuwa pamoja nasi katika kutufahamisha maelezo hayo. Nafikiri niwape ruhusa na nyinyi pia muweze kufuatilia matukio hayo kwengineko, lakini sisi tutakuwa tunaendelea kusikiliza mengi kutoka mahakama. Nasema asante sana wakili Nelson Havi, wakili Joe Kalende.
Asante.
565 of 2024, Rigathi Gachagua versus state law.
My Lords, Your Ladyship, in petition number 565 of 2024.
Why do you have two counsel standing?
Good morning, my Lord.
Good morning.
Good morning, my Lord.
Good morning.
Principal Presiding Judge, my Lord Justice Murima, and my Lady Judge. I am standing as the Attorney General, and I was going to address you pursuant to Attorney General's Act Section 7, which provides that I take precedence. May I have your advice?
There is no objection. That is the correct position.
Thank you.
So,
You will take the quorum.
yes, I was going to request you that we take the quorum first. I'm Dorcas Odura, Attorney General, Senior Counsel. The Attorney General has also been sued as a party, and therefore representing the Attorney General is Professor Gibi Mwigai, Senior Counsel. Shadrach Mose, the Solicitor General. Deputy Chief State Counsel.
Emmanuel who?
Emmanuel Bita,
Where is he?
I'm present, Lordship.
who's been swamped. And Charles Mutinda, Deputy State Counsel.
Present, my Lord. Present.
For the National Assembly, we have Eric Gumbo,
I'm present, my Lord.
Paul Nyamodi,
Present, my Lord.
and George Murugara.
Present, my Lord.
For the Speaker of the National Assembly, we have Benson Milimo,
Before you, my Lord.
Josephat
Just
Kuyoni.
too fast.
Oh, sorry.
You introduced Mr. Mugara for.
Mr. Murugara George for National Assembly. For the Speaker of the National Assembly, we have Benson Milimo,
Present, my Lord.
Josephat Kuyoni.
My Lord, I'm present.
Just for who?
Kuyoni. Kuyioni. For the Senate, we have Professor Ojenda Tom, Senior Counsel,
Present, my Lord.
Moni Mukele Edwin,
I'm present, my Lord.
and Senator Hilary Sigei.
I am present, my Lord.
Money who?
Moni Mukele Edwin,
And Professor?
and Senator Hilary Sigei. That is for the Senate. For the Speaker of the Senate, we have Mercy Tanji, and Peter Wanyama.
I am present, my Lord.
For Professor Kindiki, CS, and DP nominee, we have Mudomi Piankolu,
I'm present, my Lord.
Moses Kosgei, and Ken Meli.
Present.
My Lords, Your Ladyship, in petition 565 of 2024, may I, at the very outset, before I state counsel appearing for the Deputy President applicant, may I, at the very outset, say that I am stating the quorum under protest. We are not willingly here participating, and we will elaborate. But Let the record show that counsel appearing for the Deputy President today before this honorable court appear at the protest. As I said, the basis will be elaborated later. I appear waited for the record. I appear with my colleagues, Tom Acharya, Elisha Ongoya, Faith Waigua, Victor Swanya, Debo Wanjiru, Andrew Muge.
This we are recording the program. Faith Waigua,
Victor Swanya Ogeto, Debo Wanjiru, Andrew Muge, George Wandati, Mr. Sakim Pa, and John
Present, Lord.
My Lords, Your Ladyship, as I sit down, I seek clarity on whether it is only petition 565 of 2024 that this honorable court has before it today, or whether there are any other petitions. I thank you.
We will take quorum on all the files that are before the court first.
Petition E015 of 2024 at Kerugoya. Petitioner David Muni Mazenge and 4 others versus the National Assembly and 5 others.
May it please your lordships and my lady judge, in E015 of 2024, the quorum for the response is the same, save for His Excellency the President, who has been sued in person and is being represented by Adrian Kamodho.
Just for the purposes of clarity, just we'll record the quorum fully.
Dorcas Odur appears as the Attorney General. For the Attorney General is Professor Igai, Senior Counsel, Shadrach Mose, Solicitor General, Emmanuel Bita, Deputy Chief State Counsel, and Charles Mutinda, Deputy Chief State Counsel.
My name is Mary Oyeke. I'm from the county of Homa Bay. Towards the end of 2019, I could feel a growth on my left breast. When the person gets checked and anything is found early, it is easier, it is cheaper for the company, it is cheaper for everybody, it is cheaper for the economy when you're dealing with somebody who is at stage 1 than it is at stage.
The following
My Lord, in this matter, I appear with Senator Daniel Manzo.
Your name, please.
My name is Kibe Mugai. I thought I'd said it to you. Kibe Mugai. I appear in this matter, my Lord, with Senator Daniel Manzo, Mr. Ndegwa Njiro, Honorable Jerry Maina, Mr. George Sankimpa, Mr. Andrew,
Mr. Kibe,
yes,
we are recording. Yes. Can you start from Dan Manzo?
Dan Manzo, Mr. Ndegwa Njiro, Senator Honorable Jerry Maina, Mr. George Sankipa, Mr. Andrew Muge, Mr. Gachagua Ruta, who is on the way, and Professor Ogada.
Professor Ogada, present.
And Kenneth Matiba is on the way. My Lord, we appear in this matter that continues to be referred as Kengoya, petition number A015 of 2024 that appeared to have been filed on the same day
So you appear for which party?
We appear for the petitioners.
Kiruboya file. Again, we appear for the first interested party, that is the Deputy President of the Republic of Kenya in this E015. We'll also again let the record capture and show that council appearing for the first interested party appear under protest. Council as follows: Paul Mwite, Tom Acharia, Elisha Ongoya, Faith Waigwa, Victor Soanya, George Wadati, and John.
Can we have that again?
Yes, I'm sorry. From what Point, my lord.
From yourself.
Appropriate time, we will be going into the grounds and basis for appearing at a protest. I thank you.
My Lord, before there were also certain clarifications that I would like to be given before the hearing for today. Direction for today's hearing can be given.
My Lord, before Mr. Kibe moves on that file, are there other files, especially file number petition E572? Is it before the bench?
High Court of Kerugoya, Thomas Kimoza. Petition E13 of 2024, and Honorable AG.
It's not before us. It's not before us. That's what we want to do.
My Lord, that matter is not before the court.
Your Lordship is being called. It is the court that you know whether it is before you know the Attorney General. And we also want to know whether it is before this court.
My lords and my ladies, kindly, with your kind permission, I would also want to seek clarification for my own petition which I have filed, petition number E567. I had information that that file was also coming up before you this morning, and I would like to know whether the same is before you, and if so, whether we can also proceed with it.
When was it filed?
It was filed on the 18th of October 2024, and it came up before Honorable Justice Mwamuye, who gave directions that it should come up actually tomorrow, and I believe that is part of the reasons why there is protest in this matter. And then I was informed that it's coming up today, so I also need clarification.
May it please the court. My name is Dr. Eboso. I'm a petitioner in E541 of 2024, a petition that was filed on 8th of October, and a petition in which we got directions on 16th of October, directing that it be brought before the Chief Justice for this bench. It raises the same issues as the issues that were consolidated, and I'm appearing in person with Ms. Ivy Mwangi, the second petitioner, and we were seeking clarification with regard to directions on that file, because as we can see, there are files that were filed on 17th of October, and which directions were given, and the bench was constituted. So we expected that the matter would be mentioned together with this one today. Thank you.
My Lord, with utmost respect, this honorable court is a court of record. And the record is very, very important. My Lord, Your Ladyship, we heard the court assistant call out petition E13 of 2024, and she mentioned the word Kerugoya. That is the file that was called out. And in order for the record of this court to be systematically and accurate and easy to follow, may I, with respect, ask that we get clarity on this file that was called out, E13/24 of Kerugoya, before we go to the other matters. And perhaps it is for this honorable court to clarify which files, one by one, are before this honorable court this morning.
Senior Counsel Paul Mute, we are giving you time to talk. You see, everybody wants to talk. There will be a time for us also to talk. So I've heard you.
Thank you.
For this morning, for the purposes of hearing this morning, the applications which are before the court are application number E0113, which was consolidated in Kerugoya before it arrived here with E04114. E0114. Then we have application number E0115, also from Kerugoya. That is application before this court. And then we give direction on those applications. And then E565. Those are the three matters which are before this court and in which the Honorable Chief Justice has constituted this bench for hearing and determination. There are articles of constitution of this bench in the court. So the three matters before the court are E565, E015, E0113, and E014. Those are the files and petitions, applications before this court. And those are the applications on which this bench has given directions pursuant to this bench being duly constituted. So any other applications which we are talking about, we have not cited them, maybe they are yet to reach us, but for the purposes of today's hearing, we have these three petitions or applications.
Your Lordship, we are well guided. And perhaps also to state for record that we also appear in E015 in protest. But further that, Your Lordship, kindly confirm that the number that is now registered in the matter that came from Kerugoya is E015. And that is important, Your Lordship, because of the purposes of administrative transfers of files. Because what was at Kerugoya, Your Lordship, was E015. Does it therefore mean that that file has not yet been integrated into the Nairobi files? And if so, then how do we appear to proceed before you, and how was the matter that we shall raise other issues? Just confirm on the question of the integration of that file with the Nairobi files, because the last file that we have should be 565 as at Friday. Are we dealing with the matter in Kerugoya or in Nairobi?
Let me deal with my Lord, for the purpose of E572 of 2024.
That file is 24 hours.
That's all I'm only saying. I have had the directions of the bench. The file is not before you. But I have instructions for the purpose of the world to take that petition was filed on 18th of October. The same day the Kerugoya file were filed. All the directions in all these files that have been taken to a graveyard is that none of these files of ours have orders. The reason as to why Kerugoya file is before the learned judges is purely because they have orders to stop the swearing in of the deputy president-elect. The CJ could not have selectively decided to have only one file before you, my lords. This is a trial of the judiciary. It is a trial that goes to the root cause of whether there is impartiality.
Mr.
Yes, my lord.
Mr. Omari.
Yes, my lord.
The file you are addressing us, we have said, is not before us. And the files which are before this court are the files in which this specific bench has been empaneled.
Thank you, my lord. Allow me to because the questions I'm raising are very pertinent, that there are files selectively brought before you, but there are others.
Mr. Omari, we wouldn't know that because, as I understand, we
only deal with matters in which we have been empaneled. We do not empanel ourselves.
Thank you very much. The empanelment authority has heard me loud and clear. Thank you, Judge.
And Lord, if you could mourn elsewhere.
I had indicated in this honorable court that there will be at least 3 clarifications. Yes.
Now, I think we need to get something right. I want to clarify how these files are before this bench this morning. The 3 files which were filed in Kerugoya, that is 13, 14, and 15 of 2024, had some interim conservatory orders issued by the court. Further to the issuance of those orders, the learned judge made further orders requesting the Honorable Chief Justice to empanel a bench. Those files were transmitted on the basis of that order to the Honorable Chief Justice's office on the 18th of October 2024. On that very day, the Honorable Deputy Chief Justice empaneled this bench to hear those matters. Thereafter, applications were filed online. I think you are all aware that we are operating online. Applications were filed online. When those applications were filed online, those are the ones which this bench gave directions for these matters to appear before us today. That is why you are here, and that is the trail, that is the paper trail as to why we're here this morning. So I reiterate the position taken by the presiding judge that we will not be comfortable dealing with any other file, even if it's related to these files, which we did not give directions for it to appear here today. So I think we can now proceed on the basis of that clarification.
Thank you, Judge.
My Lord,
just a minute, please.
Perhaps just to add that the numerous other petitions that are coming up, I think the process is ongoing. Maybe not all the files have been transmitted to the bench. Maybe by the time we leave this courtroom, other files will have been transmitted to the bench. But as we speak now, here and now, these are the only files that were transmitted to the bench and in which there are applications where the bench gave directions for hearing today. That is not to say that those are all the petitions there are. We don't even know whether the transmission has been done yet, and that we will go back and find all the other petitioners whose concerns are valid. Perhaps those files will now be before the bench formally.
Yes, my Lord, I believe now I can be able to make the clarifications. We are starting with the immediate background that we need to make these clarifications, and we take into account.
Let us finish with quorum first.
I was assuming quorum was.
No, there's a quorum in E013, which was consolidated in Gachagua.
With E014. Let's take quorum on that file.
Your Lordship is seriously something wrong. And I believe it is important for us to put things into proper perspective. Because when you call the matters, if a team was not part of what was called, I've not had it, perhaps it could be called. Your Lordship, in E015, there has never been a consolidation. To the best of my knowledge.
What are you talking about consolidation? Nobody has talked about any consolidation. These files have not been consolidated. I think that is the next process we'll be going into. Nobody has talked about any consolidation. If you look at the record,
you will find that the directions for today's hearing are given specifically on each and every file. There was no consolidation of any matter. No matter has been consolidated. So let us not dwell on things which really are not before the court. Now matter has been consolidated, and let us proceed from there. If you want to apply for any files to be consolidated, that is okay. As we speak now, there is no consolidation. The directions from this court were very specific on 3 different files.
My Lord, I'm more guided, but when Justice Mrima was giving the clarification, I never heard him clarify whether the Kirogoya file has been integrated into the Nairobi system. Because we cannot be dealing with a file that is reading Kirogoya. Because of course, if there is no integration, Your Lordship, then there is a rat that is smelling.
My Lord, may I say something?
Let me answer you. You said that records speak for themselves. And for record, matters which came from
Kirogoya came with their own record. And the record states here that the matter herein is consolidated with petition E014 of 2024 and the same to be delivered in the Chief Justice for empanelment of bench in terms of the ruling in petition E014 of 2024, a copy of which shall be placed on this file. So your own matter coming from Kerugoya was already consolidated. Those proceedings which took place in Kerugoya consolidated these two files. So let that not be an issue here, please. On the directions issues on 11th by Judge Richard Mongo, these were the directions. The petitions, the petitioner in E 014-2024 to serve their amended petition on all parties. Similarly, the petitioner in E 013-2024 to serve their petition on all parties. Respondents to the petition to file their responses by noon of 17th of October 2024. Given that the files are being routed to Honorable Chief Justice forthwith, the party's response to the amended petition and petition E013 of 2024 may be filed in Kerugoya under the Kerugoya case tracking system online, whereupon they shall be forwarded to Nairobi. So these proceedings took place in Kerugoya. So this court has not consolidated any matter. Petition number E014 and petition number E013 are hereby consolidated. The parties who appeared before the Kerugoya court were given those orders. Those were your orders.
And with your permission, Presiding Judge, the reason why Nairobi has not opened another file to put together all the files from Kerugoya is this. Going by the orders which were issued by Kerugoya court, there was a specific order that because of the transmission, parties will still file their documents under the Kerugoya CTS, that is the court tracking system. We had to hold on to that so that not to disadvantage any of the parties until we appear today. Those are some of the things we will deal with here and make orders to the Honorable Deputy Registrar to formalize that. So there should be no cause for alarm. We will put everything into its place. Thank you.
I presume we will now raise the issues that we want to raise, particularly arising from the issues in Kerugoya. And I do not know.
Then proceed and take quorum on it. They were consolidated, so we will not take further quorum on this one.
The Attorney General, I don't know, I have indicated to the court earlier, I need to raise some clarifications.
Section 7 of the Attorney General's Act.
You had already asserted to speak. It doesn't override the Constitution. It doesn't override my right to represent my clients.
I'm repeating it.
Can she then say her piece? I say mine.
Which matter are we now dealing with?
My Lord, I wanted to say that the only matters before this court are the matters which had ex parte orders. The matters that came from Kerugoya E13 and E14, although consolidated, they were filed before impeachment and they have no conservatory orders. E13, we have E15.
E15 has
conservatory orders, but E13 and E14, although from Kerugoya, they were filed before impeachment and they had no conservatory orders.
Yeah. I hope I can then be heard without other interferences. My Lord, I'm leading the number of advocates in this matter from Kirinyaga, E015.
Kerugoya 15.
Yes, Kerugoya 15. Yes. My Lord, the clarification that I seek to raise emanates against this general background. The first one, my Lord, is that there was a sitting on Saturday, which the court has since explained how that sitting occurred. With regard to that sitting, my client wrote a letter to the Honorable the Chief Justice which has been placed on record in an affidavit in an application before you, that protesting, amongst other things, that the practice in which a Saturday sitting would be convened for purposes of hearing the executive and organs of government that have violated fundamental rights is a practice that is prohibited under the 2010 Constitution. That letter is on ground. We do not trust that the Honorable the Chief Justice could actually do that because she knows the history about what used to happen. But we now learn, Your Lordship, sir, that you are convened by the Honorable Lady Justice William, the Deputy Chief Justice. Lady, my Lord, arising from that are one, a legal issue and a matter of Article 150. My Lord, under the law, and we do this every day, I practice public law every day. Arising from that issues of the communication, speaking for 015, we expected that the general procedure would be, and that is what the orders implies, and required us to come on Thursday this week, that when the Chief Justice appoints a bench, she will do it in writing as required under Article 47 of the Constitution. We will be given the number of those judges and the day that they will be sitting. This day, we have not received officially, because even when the sitting happened on Saturday,
My Lord, may I
think I have a right to raise those issues.
Let's give
Mungai.
I just wanted for good order. Okay, is that a clarification? Mungai?
My Lord, I am Mungai. I believe he will in response as soon as I'm done. Let me finish.
My Lord, I wanted to assist the court because my learned friend has, I believe, filed a substantive application, so that the court does not hear speeches in vacuo. My learned friend should identify what application he is ventilating, so that even we taking notes know what we should be responding to. That's all I want to
say. Professor Boigai was a former Attorney General. I respect him. He was also my teacher, my professor for criminal law. But my Lord, the point that I wish to make is that I am acting for specific clients today, and that's the court. I should be heard in silence. He will respond. And I indicated that we have formal applications. What we are raising is an issue that is arising from what Judge Murima has indicated. We could not put it earlier in an application. So if I may proceed, my Lord, the issue is this, that we expected a notification in writing that these judges have been appointed and they would sit on a particular day. All those notifications, including in cases of abductions, have been that the first sitting by a bench has been on a working day. All applications, and I'm aware of this as a fact. So then the first clarifications would be, on what basis would, in an application by the executive, be convened on a Saturday? That is a substantive issue because of the second reason that our background that we are giving. My Lord, under the 2010 constitutions, the constitutions provide for the Bill of Rights. My Lord, under the former constitution, under the former constitution, we used to have a practice in which we had an officially a bill of immunities for the state, where the constitution, the state could conduct its business on weekends and outside court sitting hours. My Lord, because of that reason, that's why I'm saying this, we are sitting here pursuant to the orders made on a Saturday. And my Lord, we are also sitting here pursuant to an order made by the Honorable the Chief Justice. My Lord, for purposes of Article 165, I believe it's 4, of the Constitution, the powers of the Chief Justice to appoint a bench is a substantive power. It is not administrative. This power, my Lord, cannot be shared by the Deputy Chief Justice or with the Deputy Chief Justice. And because it cannot be shared with the Deputy Chief Justice, it is the reason why I say two things. That our instructions is that we must move this court immediately to set aside that order on the basis of its unconstitutionality. The Chief Justice of Kenya cannot appoint anyone, any judge, pursuant to Article 165(4) of the Constitution. And we shall place here the Deputy Chief Justice a formal applications. Issue number 2, my lords, arising from that.
Let us be discharged the directions of empanelment.
My Lord, I am saying that we shall make a formal applications to discharge that order made by the Chief Justice, Deputy Chief Justice. That's what we are indicating. My Lord, number 2, and it is implied in the applications for disqualifications that we have filed. Number 2 is that we raise the issue that for purposes of the Saturday sitting and today's sitting, and the thing is out there in the streets and the Republic of Kenya, is that a special bench would be appointed for purposes of vacating the orders that were made. My Lord, I have a lot of respect for all of you that have appeared before previously. But my Lord, pursuant to my instructions that would be the case, 3 issues worries us. Number 1, we had a sitting on Saturday, the practice of the former constitution, where the executive enjoyed special privileges. Number 2, my Lord, is that we have confirmed that the only files that are before you are files where we have interim conservatory orders. So that, my Lord, and it is important that this issue is speak for the 190 and with a clear conscience. 2 things. My Lord, the first thing would be this, that if this matter is going to be conducted like today on the basis that only those matters where the Attorney General is itching to set aside conservatory orders are the ones that are going to be heard, there would be something wrong because other cases that are even officially before you and probably assigned to you by the actual Chief Justice of Kenya are still pending. So what was this where you prioritize the state as it used to happen those days before we had a new constitution? Issue number 2, my Lord, is this, the issue of bias. And this is bias by the Honorable...
I think, Mr. Mungai, you are going beyond ordinary comments. If you have an application which addresses those prayers or those issues, I think you better...
There is another issue that does not have to do with those prayers. Well, the last issue, therefore, would be this. If assuming that cases that were supposed to appear before you are cases that came after the impeachment, my Lord, there are about 4 matters. One of them in which I appear. And this is a fundamental issue. That matter is coming on Thursday. Okay? An express order of the court that has not been set aside. The question would be this, for purposes of good order, and for purposes of us making this application, why would it be difficult even for this bench to order all cases, because that is the right to equality under Article 27 of the Constitution, that deals with the same subject matter come on a specific day where all parties have notice, so that even the issues that we are raising against the Deputy Chief Justice can be formally put on record, so that we do not have this anxiety that somebody is speaking off record. But Lord, why I say as I go to see it, why I say this is important, is this. The matters before you over and over again, the repeated question has been, the right to fair hearing is being sacrificed. Under Article 25 of the Constitution, fair hearing cannot be taken away even during an emergency. It is an absolute right in this country. So that, my Lord, arising from that, the question that we would like us to be addressed is that to say that we are going to conduct matters by installment, and the only justification for the chosen installments being that the Deputy Chief Justice is biased for the state and has therefore constituted a bench that can be able to hear the state's application, is clearly not permissible. So that, my Lord, I urge the court to hold.
I would not, please, we should not bring the DCJ conduct at this stage, because I think that the DCJ discharged her administrative duties the way it should be done. But if you have an issue with that, please don't make a generalized complaint.
Well, this is not raised. It is in writing, and we are making a formal application to ensure everything is done on record. And that right, as I sit down, the issue of that right is that we have had a situation before the National Assembly, before the Senate. It didn't seem to matter. Before the High Court, my lords, I submit the right to fair hearing under the Constitution must count for something. Otherwise, Article 25 would effectively have been amended to please the state. I urge you respectfully.
We hear you.
My Lord, sir, just to add on what my learned friend has submitted on, I will give...
With the permission of the presiding, I wish to say that you can sit down. I wish to make this clarification. The matters which are before us today, the three matters which are before us today, are not here on the basis that some conservatory orders were issued per se. I have stated and I'm repeating. The reason why these matters are before us today is that after the issuance of the conservatory orders, subsequent applications were filed. The applications were filed after the empanelment. Those applications were filed online. We deal with matters online. And it is on the basis of only the applications which were filed and dealt with online, that is why we are here today. So I want to correct the insinuation that we are here only to deal with the matters in which conservatory orders were issued. We don't know how many conservatory orders were issued. We are only here to deal with specifically the applications which were filed, which came to our attention. So kindly let us be as factual as possible. We will deal with all the matters. I can assure you there is no issue about any of the things you are raising. If you have any substantive issue, we are here. If the application for recusal, there is no problem. We will hear. If we feel we have to get out of this, there should be no problem. We are all here to defend the Constitution of Kenya. So don't you worry. Don't you worry. Give us time. Let's take this thing step by step, and we will do the best we can as a bench. Thank you.
Allow us to worry when we have crowds.
Senior Counsel Mute and Counsel Negua, you know, when you argue the way Mr. Mugwe has argued, that court start on Saturday, you are arguing on both sides of the court. You know that we work online, and most of you know that matters reach us anytime, at any time, whether at night, and that is what the new constitution and the e-filing system has brought to this country. So when you argue selectively, you mislead the people. You mislead
You mislead the people outside there that court sat on a Saturday. There's nothing like that. We attend to matters online as and when they come. But we have had Mr. Mugai, let it not be an exchange between the court and yourselves, because we are really very neutral party. Let us hear also from the other side.
We haven't finished. In E015 in Kirigoya. We haven't said our piece, and Elisha Ogoya will be making.
But my Lord, do give us, these are very weighty matters. This E015 in Kirigoya, the orders of your brother, Mr. Justice Mungo, were given at 4 p.m. Where did the file come from Kirinyaga to go to the Deputy Chief Justice? It is 2 hours drive from Kirinyaga. When did the Deputy Chief Justice sit in the middle of the night on Friday to give directions? Permit us to articulate these issues for the sake of the nation. We are not just dealing with the removal and the challenge to the removal of the Deputy President. We are dealing about the President that will be set for the removal of Deputy Presidents in future and the removal of Presidents in future. Elisha.
My Lord Presiding Judge, I want to renew my request that the court permit us to be orderly. We are now about to hear a second speech, a third speech, a fourth speech. This court, as we have been told by the senior most advocate here, is a court of record. What application are we hearing so that we on this side can prepare to respond? We cannot respond to speeches. There is an application here, if I may, the Honorable P.K. Moite. There is an application for the recusal of judges. It is the right of my learned colleagues to bring such an application. But having brought it, they should then confine themselves to it, then we can respond to it. But we cannot sit here the whole afternoon listening to speech after speech intended for another audience other than this one.
No. There's no other audience.
Let us be clear on this. The applications before this court, we have stated which applications are in this court for hearing today. We have no authority to call any other file, because files, when there's a prayer for empanelment of a bench, those files go direct to the Honorable Chief Justice. So we have no authority to call any other file to ourselves. That will be quite unprocedural. So what we have here are the 3 files which we mentioned, in which there are interim orders where one party is seeking to lift those orders. If there is an application for recusal or whatever it is, I think you really need to put it on record so that we deal with it, and before any other thing, we can deal with it and dispose of it one way or the other. But I don't think it's really necessary to have speeches in the absence of specific application and prayers.
Your Lordship, the so-called speeches have been invited by the disclosure from the court. We, the advocates are caring for the petitioners, we were not aware of how the bench was constituted. So when it was disclosed to us that the bench was constituted by the Deputy Chief Justice, it necessitated us to address you, Your Lordships, on Article 165, Clause 4. On the constitutionality of the constitution of this bench, to hear these 3 specific files. And that is the issue that we want to address even before we go to the application for recusal. Because it's our humble view, Your Lordship, that the so-called empowerment of this bench to hear these specific files is itself unconstitutional. By the reading of Article 165, Clause 4, It is our reading that the only person who has the capacity to empanel a bench is a Chief Justice. So we want to urge this court to perhaps interpret for us whether the Deputy Chief Justice can empanel a bench. Number two, Your Lordship, is where did the Chief Justice get the authority to empanel the bench? Was the Chief Justice present? Why did the Chief Justice execute her functions and her mandate under Article 165 clause 4? What was the necessity of the delegation of this function? Those are pertinent issues, Your Lordship, that requires clarification before we go to the roots of the matter, the crux of the matter. It's our submissions, Your Lordship, that the Chief Justice, who is exercising delegated powers, cannot further delegate the Deputy Chief Justice. That's why the Constitution is in white and black, that the obligations and the duty belongs to the Chief Justice. Finally, Your Lordship, the reason why we find ourselves in this situation is because of what the court is struggling to explain to us. That 3 files have graciously generated expediency, and the other files that were consolidated, that 6 file with the lead file 522, have no reasons why they should be before you. Noting that, Your Lordship, those matters were equally certified as urgent and raising heavy constitutional matters. When I looked at your orders, Your Lordship, that you issued on us today, you repeated the same, that they raise weighty constitutional matters. Why are we being discriminated by the court that our files are not considered as a priority, and that the files with orders are the only ones that the court is sitting on a Saturday? The Chief Justice is empaneling, the Deputy Chief Justice is empaneling the bench. We are called, like in a lightning speed, to appear before you. Is it not because there are some orders that the state wants to vacate? You cannot run away from that reality, Your Lordship, most respectively.
My Lord, with your kind permission, for the record, Dr. Kamono for the civil respondent in issue 15. I believe the reason we are here and the reason why we took forum is because we recognize that there are different parties in these proceedings. So it will be abominable for a section of the parties to seek to colonize these proceedings and treat them as if they are the only ones entitled to the office of the court. So in this regard, my proposal is as follows, that each of the parties whose representation has been taken gets an opportunity to indicate to the court what applications they have before the court, so that we're able to proceed methodically. And each party then, the court can then give directions on how we move to treat each of those applications. Otherwise, we may be here indefinitely if each of the parties takes the opportunity accorded to make lamentations, to make speeches, and to mourn. So we respectively urge that we get an opportunity for each of the parties to ventilate the issues, because the federal respondent has a pending application which is duly filed, a preliminary objection which even contests the jurisdiction of the High Court to hear the matters, because it is a matter relating to the nomination of a presidential and overrepresented president, which in our view lies squarely within the domain of the Supreme Court. So we once accorded an opportunity procedurally, we shall ventilate all those issues, and hopefully the matters being raised or to be raised about recusal and so on, they will fall by the wayside. Thank you, my Lord.
Lord, for the first interested party.
Mr. Goya, just a minute. I was about to interject when when counsel, yes, Mr. Degwa was addressing, and that is exactly why I wanted to. I wanted us to have order in the way we conduct these proceedings. And I was about to ask Mr. Degwa, after all that, what is your application?
Your Lordship, I'm very clear in my application. My application for which
the application can only come after I have spoken.
We are now making an application. You respond. What is it that you want? Your Lordship, permit me to make an application under the Mutunga rules that following the disclosure of the court this morning that was made by Justice Murima, that this honorable court does determine whether the Deputy Chief Justice has the power to empanel the bench under Article 165, Clause 4. Your Lordship, and whether, if she has any power of that nature, the same ought to be communicated to the members of the Republic by the Chief Justice, that is to say, Your Lordship, that the Chief Justice has delegated her powers under Article 165, Clause 4 to empanel this bench. Your Lordship, this is the background of my application, that on the 14th of October 2024, the Honorable Chief Justice did empanel this bench to hear and adjudicate over 6 matters which were consolidated with the lead file being 522. And the files that were consolidated, Your Lordships, my lady, were 522, 509, 537, 528, 525, and 506. Your Lordship, it is our humble submissions that this bench was exclusively empaneled to handle those files, and that the communication was effectively made to the parties by the Honorable Chief Justice. I am giving the background of my application, and that we are aware that subsequently other files, and the most important one is E014 of 2024, which came from Kerugoya, was equally slated for empanelment before the Chief Justice. To date, Your Lordship, there is no communication from the Office of the Chief Justice other than this morning that this file was equally empaneled and designated for hearing by this bench. Your Lordship, the other ground is this, Your Lordship, that when we appeared before you on the 16th of October, Your Lordship, we sought your indulgence, Your Lordship, to have a further mention on the 18th of October.
My Lord, I'm sorry we are constrained to interject to seek your guidance. My name is making an application before this bench, complaining about wrongs supposedly made by the Chief Justice and the Deputy Chief Justice in bringing us to this session of today. For me, the clarification I wish the court to provide is whether an application of that nature can be made informally without the CJ and the DCJ being made parties to that application and being offered an opportunity to explain, so that to be fair on these state officers, it's easy to speak to the gallery and cast all manner of insinuation and aspersions against them. And if my Lord finds that an application of that nature cannot be made informally without actually filing a formal application and joining the CJ and the DCJ so that they have a chance to respond to these insinuations, I suggest again, and I beg the court, I'm a very junior counsel, but Professor Mugai wonders that we run the risk of coming to a court of law to speak to the gallery. In parliamentary language, what I fear is happening is what is called filibustering, my lord. To filibuster is where you go to a forum intended to deal with the business of the day, and you keep making speeches upon speeches that have no bearing on the business of the day, where the motive is to ensure that the business of the day is not conducted. To the best of my knowledge, the business of the day there were applications on their side, there were applications on our side, and the court was graceful enough to give both sides an opportunity to come today to ventilate those applications. Instead, we've lost 2 hours, my lord. We have not been addressed on those applications. We are just filibustering.
My lord, perhaps if I may.
Yes.
My lord, you are being invited to interpret Articles 161 and 163, 1B, 1 and 2, which designate the Chief Justice and the Deputy Chief Justice as head and deputy head of the judiciary. And you're being asked to inquire into the manner that they perform their duties as head of the judiciary and to interpret Article 165(4). That can only be a substantive, through a substantive application to which all parties must respond. I think my concern then, and Legbo and my friend Kibe, is that you are taking the court for a long ride and you are ending up wasting a lot of time in court. I wish you could go to the issues. If the question is, if you are ending up with an application for the disqualification of the bench, why can't you go to that point instead of beating around the bush, as you would say?
My lord, if I may, just to bring it to the court's attention, that the issue that my learned colleagues have taken up rather dramatically this morning is an issue that they have taken up with the Chief Justice by way of a letter. Before they came to court, they have taken up those issues with the Chief Justice by way of a letter. If that is the avenue that they have chosen, then let them deal with it by way of the letter. It isn't anything that should take your lordship's time. That letter remains. They have written it to the Chief Justice. We have been copied on the letter, and we await the learned Chief Justice's response to the letter. It isn't anything that should take up time this morning.
My lords, if it pleases the court, my name is Milimani. I am acting as person. We filed an application for the certificate of LLC on the 8th of October 2024. Before this bench was impaneled on the 14th of October 2024. Unfortunately, some of the cards we were seeking have been overtaken by events. My lord, and today, as you have heard, our application has not been placed before you, and we are just concerned that our application will once again, investment and once again overtake our application. My lords and my lady. So we're asking with the kind indulgence, if you would please at least allow us time, my lords and my lady, for our application to be consolidated and heard together with the other applications that have been heard today.
Madam Chair, for the 15th interested party in 15, may I just be heard for 1 minute only. My Lord Judge asked an important question. How do we move forward? Now the paradox as I got it, because I don't make speeches, is that my colleagues accused this side of making speeches, and in the process they made speeches. But having said that, my Lord, an issue has arisen following disclosures by my Lord Justice Bremer about how this bench has been constituted. It's now apparent that the petitioner and the first interested party in petition 15 have an issue with that. We suggest that we be given time to file a formal application. It could not have been filed earlier because the disclosure has been made here. And since that issue goes to the core of your capacity to sit, it ought to be resolved preliminarily. Whether you have been properly empaneled is the most preliminary of preliminary issues. We urge that you give direction in the nature of a timeline when that application ought to be filed, a timeline when responses will be filed, then give us a return date to come and canvass that application on whether you are properly constituted. Because if it turns out that you are improperly constituted, even the issue of recusal becomes secondary. Yes. But if it comes out that you are properly constituted, then the issue of recusal now follows. I urge that if we follow that route, in accordance with my teacher's guidance, Professor Gideon Muigai, there will be greater order and coherence. And I thank you.
Is that an adjournment? Is that lawyer applying for an adjournment? Because he's saying, and perhaps rightly or wrongly, that even the recusal petition comes after the termination of the question when panel. If that be so, they normally leave court, they may leave the Senate, may leave court. Let them say whether they are applying for adjournment.
Is that remark, they normally leave court, the left Senate palatable in this court, my lord? I need that answer first. No, is that remark palatable before my lord and my lady? My lady, because, you know, we have decorum at the bar. If you have a professor of law misbehaving at the bar, then there's a problem. I'm urging that you direct that remark be withdrawn first, then we make progress. I'm urging, my lord. The remark was made in your presence. I'm urging it to be withdrawn first, then I can respond.
My lord, I have no problem in withdrawing the remark. But the point is, it is a veiled application for adjournment. Because Mr. Moyle is saying that the court must address the question of empanelment before the recusal. So I can just make the point.
I am answering the question now, but I know that he has withdrawn. He said he has no problem with withdrawing, but I didn't withdraw. I want him to withdraw first, my lord, because I'm entitled to dignity.
I have no problem withdrawing.
No, my lord, you must withdraw.
I withdraw the remark.
Thank you so much. Thank you. Thank you. Let me now address the question as addressed. My lord, Professor Jenda was my teacher and my mentor of many years. I have no disrespect for him. I just want my own dignity asserted, because I can't protect my client's dignity if my own is in question. But having said that, my lord Judge Mrima, you are a witness that the issue of how this bench was empaneled has been disclosed here when we are here. We have raised concerns through learned colleagues Kibe Mungai and learned colleague Mr. Ndegwa that we now want to take that as an issue. My colleagues have rightfully submitted that matter requires a substantive application. Rightly, we agree with them fully. But you'll agree with me that if you are improperly constituted, then you cannot make one more step. It's therefore in that request that my Lord Judge Mrima asked, how do we move forward? I also had my learned mentor, Professor Gideon Muigai, again ask, how do we move in an orderly manner? I'm suggesting let that substantive application be placed before you. Being as preliminary as it appears on the face of it, give back-to-back timelines on the compliance by the parties. Let the parties come and now formally address you on that question. Let us have a determination on that question. I humbly plead.
Speaking for too long. Thank you. Allow me, my lords and my lady, to address the issue of disclosure, which is actually being attributed to Mr. Justice Mrima. And sometimes it's good to tell the truth, because the issue of how this bench was empaneled has not come to light just now. They actually knew of it, and they should have, they would have found out the letter which was written this morning, which we have. It was received on that. It was written on the 20th of October, as actually one pertinent question. It is posing whether the file was actually taken to the Chief Justice and at what time. So they are actually knowing something regarding that. Then we are dealing with constitutional functions under Article 165(4), which means they were saying only the Chief Justice can constitute this bench. So they actually knew how the bench was constituted, and possibly the only reason we should be given is why the file was taken to DCJ, possibly because of the absence of the Chief Justice. They will have to take themselves to why we have the Chief Justice being the head of the judiciary and the Deputy Chief Justice being the deputy head of the judiciary. In the absence, that's what the Constitution provides. In the absence of the Chief Justice, it is the Deputy Chief Justice who is supposed to do administrative work, which, and here, let's not filibuster what we were told. That as we do in the Parliament, you go around in circles to waste time so that the motion possibly is defeated by a fluxion of time, which is what they are trying to do. The truth is this: it is well known in practice that the court's administrative functions can be done at any time of the day, including this bench can sit up to midnight without anybody questioning. So the issue of when the Chief Justice, Deputy Chief Justice sat does not arise. As to what happened on Saturday, again, this is purely administrative.
For the Speaker of the Senate, may we be heard? Yes. My Lord, allow me to assist the court. And my Lord, listening to the speech, not an application made by my colleagues, the petitioner side, my Lord, I just want to state that the Deputy President filed his petition on Friday. And my Lord, on the same day, he got conservatory orders. My Lord, he accessed justice in accordance with the framework in Article 48 of the Constitution. But my Lord, justice cuts both ways. My Lord, the respondents on the same day filed an application to set aside those conservatory orders. My Lord, properly constituted, this court has issued directions that those applications be heard today. My Lord, under the Mutunga rules, there is a fundamental doctrine which we are all missing. The doctrine of timely resolution of such kind of disputes, especially disputes that are of immense public interest. So, my Lord, if you look at the application which has been made, or speech made by the petitioners, my Lord, you will see that they want to split hairs. My Lord, the Constitution expressly provides that the Chief Justice shall appoint a bench to sit on matters which raise substantial questions of law. But my Lord, at the same time, that Constitution which requires to be read conjunctively says the Deputy Chief Justice shall deputize the Chief Justice. So my Lord, what is the fuss about it? So my Lord, my request is that the application, this speech by the petitioners is solely meant to delay the business of the day. And my Lord, I request in public interest, my Lord, I request in public interest that you give directions. We proceed with the application. We are here to respond the application for conservatory orders. And my Lord, you also hear our application to set aside the conservatory orders. My Lord, that will make juridical sense and promote public interest. Thank you.
My Lord, if I may just add.
This court has the control of the proceedings. And this is a very weighty matter. It concerns the Deputy President of this country. I will not allow everybody to speak, because if everybody is going to speak, we are going to head nowhere. A challenge has been posed on the validity of this bench to sit. This is the direction we are making. The application challenging the validity of this court to sit must be filed within 1 hour and responded to within 1 hour. We will come at 2 to listen to that application.
Wangu, hapo kulikuwa ni mahakamani Milimani ambapo hatma ya Gachagua kotini ilikuwa inasikilizwa, na bila shaka imekuwa ni muda wa taifa kuweza kujijuza mawili matatu kuhusu masuala ya kisheria. Kufikia sasa ni kwamba Jaji Eric Ogolla ambaye ni miongoni mwa majaji wengine wawili wa jopo lililoteuliwa siku ya Jumamosi kuweza kusikiliza kesi hii, ameomba mahakama ichukue muda wa masaa mawili hivi waweze kusemezana na kujua itakuwaje. Hii ni baada ya mawakili wa naibu rais aliyeng'atuliwa bungeni Rigathi Gachagua kuweza kutoa mwongozo kwamba jopo hili halipo ama liliweza kuletwa pamoja visivyo ama kinyume cha sheria, wakisema kazi hiyo ni ya jaji mkuu na kwamba jopo hilo ililetwa kwa pamoja na naibu wa jaji mkuu. Hivyo basi, mtazamaji wangu, ni kusema hata kesi ya naibu rais Rigathi Gachagua aliyebanduliwa kupitia bunge kuu na lile la seneti bado haijaanza kusikizwa. Kikuu zaidi ambazo kimeweza kudhihirika hapo Milimani ni mawakili wa Rigathi Gachagua kuweza kuomba koti hilo kwamba majaji Eric Ogolla, Anthony Mrima na Daktari Fred Mugambi Konrathi wako kazini visivyo. Sasa moja kwa moja tuseme na wageni wangu, tutaanza na wewe Kathy. Mtizamo wako, umeona mambo ambayo yameelekea kotini. Ogolla amesema tujipe muda kidogo, masaa mawili hivi